Are you ready for a deep dive? I think we need one here. We have a U.S. Attorney's Office in Washington, D.C. that issues subpoenas like lollipops, and only on Republicans, Republican office holders, Republican attorneys, just crushing the Constitution and shredding attorney-client privilege everywhere. And what for? Well, they're throwing a very broad net, trying to get Trump, Republicans, Republican state legislatures caught up in a massive criminal conspiracy. So I want to break this down with you. It's very, very necessary because this is your republic, and this is the most outrageous intimidation effort in history, I think, of a political party. So let's focus mostly on the so-called fake electors, okay? Let's take a look at the language in the Constitution of the United States. Article 2, Section 1, Clause 2 of the United States Constitution. Each state shall appoint in such manner as the legislature thereof may direct a number of electors. That's the opening sentence. Doesn't say the governor, doesn't say the Supreme Court of the state or any court, doesn't say any board of elections or secretary of state. It says the legislature, because they felt the legislature represented the people best of any representative body in existence, the state legislature. People have called this the independent legislature theory. Which people? On the left, who want their courts run by Democrats to make decisions about elections in the states. But this could not be clear, and you would not have a constitution today if the state legislatures were not involved in making the decisions about the appointment of electors to choose presidents and vice presidents of the United States. So that's number one. I want to take Pennsylvania as an example. This is very important. Stick with me. In Pennsylvania, they have an election law, like every other state, but they have a very difficult and complicated method for amending their constitution. It's one of the oldest constitutions in America, even though Pennsylvania is one of the oldest colonies. And in order to get an amendment passed in Pennsylvania, you have to go through multiple steps. And in order to change the election laws in Pennsylvania, you can't do it by statute. You have to do it by amendment to the Constitution. Now, prior to the 2020 election, Mark Elias and other lawyers working for the DNC, working for the Joe Biden campaign, they brought scores and scores of lawsuits and administrative actions, particularly in battleground states, to try and change the election laws to benefit their party and Joe Biden. And they largely succeeded. The Republicans were often caught flat-footed. But they forum shopped to pick states where they felt the courts would go their way and they felt the governor would, because we're talking about, in many cases, Democrat governors. In Pennsylvania, the Supreme Court has 7 members, 5 of whom are Democrats. Radical left-wing Democrats elected mostly by the teachers' unions in the state of Pennsylvania. Again, the Republicans were caught flat-footed during those elections. It's very partisan, it's very political, and in that sense, in my view, it's very corrupt. Much like the Supreme Court in Florida in 2000. Now, the problem was, by 2020, the election, the governor and the court and their surrogates were changing the election laws in Pennsylvania from what existed. They weren't using the Pennsylvania Constitution. That would take too much time. They wouldn't get what they want. So you had lawyers coming in, Democrats, trying to change the rules, change the laws, and the Supreme Court of Pennsylvania did it for them. Again, much like the Supreme Court of Florida in 2000. So lawsuits were brought, including a suit that was brought to the United States Supreme Court. Back in 2000, William Rehnquist was the Chief Justice, and they told the Florida Supreme Court enough is enough. And in Florida, you might recall, the state legislature was convening to overturn effectively the decisions of their state Supreme Court and to send an alternate list of electors to the National Archives, which the governor would first have to certify, the governor being Jeb Bush, the election of his brother, George Bush. I know I'm going quickly, but stick with me. I'll get to this. It's very important to lay the groundwork. Well, when the case was brought to the Supreme Court out of Pennsylvania, not for identical, but similar reasons, the court wouldn't take it. Sam Alito obviously wanted to take it. We believe Thomas and Gorsuch wanted to take it based on what I read in the paper. But that's all they could get, and it takes 4 justices to take it up. And so the election in Pennsylvania was conducted under processes that had been changed by the Democrats on the Supreme Court of Pennsylvania at the behest of the governor and these Democrat litigators. So many people in Pennsylvania were furious about this, including Republicans in the state legislature, including, I guess, President Trump and lawyers working for President Trump. And so they decided, you know what we're going to do? We're going to send an alternate group of electors to the National Archives. Now, they couldn't get the Republican legislature to vote for this alternate list of electors, so it was always going to fail. The Republican legislature can send an alternate group of electors, but members of the legislature and others really don't have much of a constitutional leg to stand on. But they gave it a shot. And they also added, when they sent their list of electors, they added in addendums to the electors' votes, documents saying that that they were sending these in case legal challenges were successful. So they wanted to have this second group of electors there in case the challenge to the Supreme Court or other courts would be successful, which they were not. Does that sound like obstruction of justice to you? Does that sound like obstruction of Congress and the Electoral College vote to you? So what are the federal prosecutors looking at? I assume they're looking to 18 United States Code Section 1505, obstruction of proceedings before departments, agencies, and committees. And by the way, those alternate lists of electors, whether out of Pennsylvania or these other states, never got to the floor of Congress. They were never considered. They couldn't get past the archivist of the United States because they have rules in the archivist's office passed by statute and by their own practices that would prevent them from getting to the floor of Congress, so they were never considered. So this criminal statute says, whoever corruptly influences, obstructs, or impedes, or endeavors to influence, obstruct, or impede the due and proper administration of the law under which any pending proceeding is being had before any department or agency of the United States, or the due and proper exercise of the power of inquiry under which any inquiry investigation is being had by either House or any committee of either House or any joint committee of Congress. All that legal gobbledygook, what does that mean? So prosecutors are hoping that they can try and figure out how to put a round peg in a square hole or a square peg in a round hole by using this obstruction statute that has nothing to do with the proceedings that I'm talking about. They see that there's an Electoral College vote proceeding corruptly, that is a specific intent crime. And so what are they saying? They're saying that these quote-unquote fake electors were sent to Washington to overthrow the election that was won by Joe Biden. Now you have a little more context, right? To overthrow it. To overthrow it? That doesn't sound like what the Pennsylvania folks did. The archivist blocked it at the door. The problem was the state Supreme Court in Pennsylvania slammed the door and would not really accept any challenges to its own changes. The U.S. Supreme Court slammed the door and wouldn't accept an appeal to fix this and enforce the federal Constitution when it comes to the appointment of electors. And so they took this step, which was never going to work, and now a U.S. Attorney's Office for the Biden administration is investigating this under obstruction. This, as I said, is a specific intent crime, and as far as I'm concerned, this is preposterous. Absolutely preposterous. Even the words fake electors are intended to create a criminal notion around all of this activity. Then they're looking at, I assume, 18 U.S. Code 371, conspiracy to commit an offense or defraud the United States. And so they're looking at the president's lawyers, maybe the president himself, if they can snag him and others. And so they put out 40 subpoenas the other week. They're grabbing people's phones and so forth. If two or more persons conspire either to commit any offense against the United States or to defraud the United States or any agency thereof in any manner for any purpose, and one or more of such persons do any act to affect the object of the conspiracy, each shall be fined under this title. Conspiracy? When you're bringing an open, what you believe to be legal, what you believe to be constitutional challenge, in case some of the lawsuits succeed, and then there's seditious conspiracy, for God's sakes. 18 U.S. Code Section 2384. If two or more persons in any state or territory in any place subject to the jurisdiction of the United States conspire to overthrow, put down, or destroy by force the government of the United States, or to levy war against them, or to oppose by force the authority thereof, or by force to prevent, hinder, or delay the execution of any law of the United States, or by force to seize, take, or possess any property of the United States, and so forth and so on, is a crime. Well, that clearly didn't occur. The roles and the responsibilities for the Electoral College are right here on the National Archives website. And among other things, it says the Constitution and federal law do not prescribe the method of appointment other than requiring their electors must be appointed on the Tuesday after the first Monday in November. After the general election, the governor of each state prepares at least 7 original certificates of ascertainment, listing the persons appointed as electors. Since federal law does not govern the general appearance of the certificate of ascertainment, the format can vary from state to state, but law requires the names of the electors chosen, the names of all other candidates for electors, and the number of votes they received. It has to be signed by the governor and the seal of the state. Well, obviously in Pennsylvania, the governor's a Democrat, so that wasn't going to happen. Each state must send at least one certificate of ascertainment to the Archivist of the United States as soon as possible after the general election. And it goes on, federal law does not govern the general appearance of the certificate of vote, so the format can vary from state to state. So it's very particular. It's very particular. There was no crime here. Fake electors, obstruction, conspiracy to defraud. This was a failed attempt to send alternate electors to the National Archivist, to Congress, to be considered. In some states, should the litigation be successful. But there's no specific intent to commit a crime. None whatsoever. The real offenses here occurred early on, before the general election in 2020. In Pennsylvania, where the Supreme Court changed the election laws in violation of the federal Constitution. They did similar things in Wisconsin, similar things in Georgia, similar things in other states. And that was by design of the Democrat Party, the Biden campaign, and their lawyers. And people were trying to figure out constitutional and lawful ways to respond to this. I'm not even talking about what happened on the steps of the Capitol on January 6th. I'm talking about the Constitution and the law. So for prosecutors in the U.S. Attorney's Office in Washington, D.C., to myopically be looking at statutes that never were intended to apply to the Electoral College process, which is supposed to be a vibrant process, a lot of give and take, a lot of fighting and battling and so forth under the Constitution. We cannot have prosecutors who cherry pick and decide that this individual or this group of individuals or this alternate or fake list of electors and so forth, they have the specific intent to obstruct justice and overturn an election. I think it could be argued that the Supreme Court of Pennsylvania had the intention of overturning an election, or Democrat operatives, or Democrat lawyers, or Democrat officials throughout the country by changing the election laws before the election in violation of the federal Constitution.
Want to see more Mark Levin? Go to levintv.com and subscribe now.